Hi friends, this is Krish the Urban Naxal. Friends, our relationship with lawyers is actually a weird one. It's not a very clear relationship. Because your lawyer is, sometimes he feels like a friend or a confidant. You know, you can tell me everything. If you've done something wrong, you have to tell your lawyer about it. You don't hide things from your lawyer, stuff like that. So, feels like a friend, feels like a confidant, feels like a consultant sometimes because you don't know something and he has domain knowledge, he knows about laws, he knows about how courts work. So he feels like a consultant sometimes. But if you engage a lawyer, he's basically a contractor. He's a contractor because you're giving him a job. What is the job? For example, I have a criminal case against me, so I will engage a lawyer to defend me in court. This is a job. This is a job I can't do myself. Why? Because I don't have the domain knowledge. Now, it's a little bit like me engaging an interior designer and saying, your job is to make my house look good. But if I don't define what good looking means, if I don't say you need to paint my walls this color because it suits me and so on, this interior designer can do things with your house that you may not like later on. When an interior designer is doing his work, you can watch and you can tell him, you can give him feedback, you can say, I don't like how you have designed my living room, I don't like the colors you have chosen for my my cupboards. You can say stuff to him and he will usually correct himself. But that's different for lawyers. Lawyers are like your contractors. They're sort of like contractors. You are giving them the job of either defending you in court or representing you in court in a case that you have filed against someone else. You want to file against someone else. So you are giving him a contract. But there's one problem with giving a lawyer a contract. One is he kind of feels like he's your boss. He doesn't feel like he is going to listen to you. He's the kind of guy who's going to tell you what to do. Now that is a problem. You can't tell him what to do because he says you don't know what you're talking about. You don't know what is going on. And he doesn't inform you about what's going on. He's not educating you about what's going on. Sometimes he's keeping you in the dark. You're giving him a contract, but you don't really know the scope of the work. And he doesn't try to explain the scope of the work. He just gives you a blank statement and says, I want 3 lakh rupees for this. I'll work for you for 4 lakh rupees. And he'll usually say it in a way that makes you feel inferior. So you feel you are engaging a contractor, but he is your superior. He is your boss. He will tell you what to do and he will save your ass. Now, this is another aspect of this, especially if you are engaging a defense lawyer. When you are engaging a defense lawyer, when you are a defendant, someone has filed a case against you in civil court or in the criminal courts, in front of the police or in front of a magistrate, you're going to feel like you're engaging someone to save your ass from consequences, from the law. My experience with lawyers is a lot of them will keep you in the dark. They don't really tell you genuinely what is going on. Often they misinform you, they scare you, they frighten you unnecessarily. They scare you, they do not inform you about your rights. They keep you in a state of perpetual fear, they keep you off balance. So these are some of my own experiences and my own findings about lawyers. And if you confront them, they act hurt, they act angry, they will go into a sulk, they might stop receiving your calls. They may not talk straight to you. They may say things like, yeah, I did you a favor by taking your case. I usually don't take a case like this. Things like that. So it's not easy. It's not easy. And if you have to say, okay, I'm going to take my case back, and I'm going to give it to some other lawyer. Now you're already afraid because you have the fear that you will find a lawyer who is worse than this guy. If this guy can be bad, someone else can be even worse. Someone else can be more unaccountable, less transparent, you know, less knowledgeable. So there is a lot of fear about leaving one lawyer and taking on another lawyer. There's also a fear about contractors in general. You don't generally ditch a contractor and take on another contractor. Here it is about lawyers, just makes it worse because there are legal consequences. Now, the law, the judiciary, you know that the judiciary is a strange place, it's a whimsical place, it is, it's a place where there are so many rules, so many procedures, you don't know what's going on. A judge will say things, you don't know what's going on. A proceeding will happen, a hearing will happen, you really don't know what's going on. I'm talking about the common man. Common man is not necessarily a poor man or even a middle class man. Even a rich man can be a common man. The common man is at the mercy of the lawyer, and the lawyer often exploits this situation. And this is experienced, I think most people will agree with me, that their lawyers don't really do what they're supposed to do. They often do what they are not supposed to do. They will not show up at hearings. They will miss dates. They will come late. They will send their juniors. They don't represent you effectively. There are times when you feel that the lawyer should have spoken and instead the lawyer keeps quiet. Or there are times when the lawyer should have said something to argue, something that you know about and he also knows about, but for some reason he doesn't say that correct thing. He doesn't say that exact thing. And then you ask him, hey man, what happened? Why didn't you say it? Why were you quiet? The other guy, the other lawyer, opposition lawyer was talking and he was arguing and you were just keeping quiet. What are you doing? And he says, he may give a lame answer. He may say that's court craft. He may say you don't understand how it is. He may say things like this judge is very moody and so you cannot say these things. You should not argue in front of this judge. They say a number of things, but the whole crux of the matter is they don't represent you as you should be represented. Then they hold you to ransom. Many people have this experience of being held to ransom. A lawyer has already taken 1 lakh, 2 lakhs, 3 lakh rupees. He tells you that he is going to fight the whole case. And after that, suddenly he starts acting like he's not going to fight the whole case. He is really tired of your case. He is really bored with your case. Or he is annoyed with you for something you said. And he stops attending. He stops attending the court. He stops taking your phone calls. He stops being responsive. He stops replying to WhatsApp. He just goes blank. He just goes blank. And you feel it's like be standing on very slippery ice. You don't know. You don't know what to do. You can't walk. You will fall down. You can't move. You are helpless. You are paralyzed. A lot of people feel this in their relationship with lawyers. So again, to summarize, what is a lawyer? A lawyer is a contractor, but the scope of his contract is very vague. He often deliberately will not define it. He does not define the scope of the contract. He will not define it in terms of how many hearings he will attend, what kind of filings he will do for you, how many replies he will file for you, that kind of thing. How many, how much of writing, filing, drafting, appearing, arguing he is going to do, and how many years he is going to do it. The way they ask for money is often upfront, all of it. So you end up giving, let us say 2 lakhs, 3 lakhs, 4 lakhs upfront. You give it to the lawyer because he demands it. He says either this or I am not taking up the case. You feel helpless even at that point. Sometimes the right thing to do is to say, well, I want to structure your fees like this. I am going to pay you after drafting 25%, after filing another 10%, after the first hearing, I'll pay you 10%. After the second effective hearing, not just an adjournment, I'll pay you another 10%, or whatever it is. So you want to stretch it out, or you want to space out your payments. And this is in your own self-interest to ensure that he does the work he's supposed to do. You need to do that. You need to get him to agree to a payment schedule which makes sense in the long run, so that even after 5 or 6 or 7 hearings, there is still money that you owe him, that you will give him. You don't owe him because you paid him for the work that he has done, but he should have a sense of wanting to earn more money from you. And if that is not happening, and if you paid everything up front, then after 2 or 3 hearings, after 1 or 2 filings, he's gone and filed the case, and then the opponent has replied, and then he has filed a reply to that reply, a rebuttal or a rejoinder has been filed to that reply. But then the guy starts dragging his feet. He may say, I didn't expect this case to go on for so long. And he will start troubling you for more money. He will start troubling you. He will say, oh, well, really, I did it very cheaply. It was not economical, etc. And then you feel you're helpless, and you pay more money because you feel you're helpless. You're helplessly paying more money. And then it's a question of, where do you draw the line? How much do you pay? Where is the reasonability? You feel helpless. You don't have any sense of control. You always need to have a contractor within control, and because of that, you should have milestones. You should have milestones for performance. You should have milestones for payment. We cross this milestone, this is the performance, this is the payment. We cross the other milestones, that is the performance, that is the payment. It has to be written. Now, that's another thing about a contract with a lawyer. You usually don't have a contract, a written down thing, properly written down with a lawyer. I'm talking about the common man. Companies, it's different. But common man usually does not have a written down contract saying this will be your performance and this will be your payment upon performance. There is no such thing. So what happens is, there is no written contract. There's only some oral thing. It's very informal. It may have come to you on WhatsApp. He's not giving you a quotation. You're not approving a quotation. There is no specified payment plan. His service is very vague. His service is basically almost given like, look, I'm going to come to court and I'm going to save your ass. And you will be like, I'm very grateful to you for saving my ass, and so I'm going to pay you. It's that kind of a relationship. If you're a defendant especially, even if you're a plaintiff, look, you're going to lose this house. I'm helping you to keep your house. So I'm saving your ass. So I'm filing this case against the builder or against the other party, whoever is trying to take your house. And so I'm saving your ass. So there is always this, I am saving you. I'm saving your ass. I'm your savior. I'm your Masiha. This sense is always there. It is not a clear deliverable like, look, we are fighting a case. This is the reason we are fighting this case in civil court, as opposed to some other forum like RERA or consumer court. These are the reasons. This is the law. These are the laws I'm going to rely on. These are the case laws I'm going to rely on. This is how I'm going to draft the complaint. This is the direction in which I'm going to go. This is the strategy. These are the good practices. These are the best practices. I'm going to follow these best practices. These are the standards. There's no such thing. There is no standard. There is no standard for lawyers. There is no standard for what is a good performance versus what is a bad performance. The promises made by lawyers, very vague. The timeline that you are led to expect, Very vague. Oh, you will get it in 6 months. You will get it in 3 months. You will get an order. You don't. There are many more hearings. And then afterwards, the lawyer is going to lose interest. He is going to hold you to ransom. He is going to ask for more money. So, how do you deal with this? What is the solution to this problem? One is write down a contract. Write down a contract and maybe even do things like go and get competitive quotations. Speak to one lawyer, go to another lawyer. Maybe you don't reveal what the other lawyer has said. You just go and consult with the other lawyer. What about the charges? Now, the lawyer is going to charge you conference fees. He charges you conference fees and it may be very steep. He may charge you 10,000, 20,000 for just talking to you for 1 hour. You may feel very scared because you're a middle class person and you say, okay, 20,000 and he just talked with me and he didn't even give me anything in writing. So I have nothing in writing. I don't know how I can, I didn't get any knowledge out of this. So how do I justify the expenditure of 10,000, 20,000? It's difficult. But I think you need to try to get lawyers to give you either no conference at all, like don't charge conference fees, just talk to me because I want to hire you, but you got to convince me that it's a good idea to hire you as a lawyer. That is one thing. Second, you need to get him to commit to some deliverables. You need to get him to commit to some schedules. You need to get him to commit to what exactly he is going to achieve and by when. And you need to also have contingencies. What happens if I don't get my order in 2024? What happens if you are saying we will get the order in 6 months? What happens if we don't get it in 6 months? What happens if 1 year passes and we haven't got the order? What does it do to our relationship? What does it do to our fee structure? Will you still be working within the same 2 lakh rupees that I'm supposed to give you? Or are you going to ask for more? You need to write it down and you need to get him to commit to something. So, you discuss with him, you write it all down, you send him an email saying, these are the fee structure we discussed. This is how we expect the case to go. Our prediction is that it will go on for 6 months. It may get over early. Very nice if that happens. But we expect it to go on for 6 months. So this is the fee structure. And this is how I will pay you. Now, the lawyer never wants a situation where you will pay him after he wins. He wants to collect upfront because if he loses, he expects you are not going to pay him. So what he tries to do is, whether he wins or loses, he wants all the payment upfront. And in order to get the payment upfront, he may actually lie to you. You may be losing the case, you don't understand the proceedings, you don't know what the judge is saying, you don't know how things are going, you are not able to read the judge's mind, you are not able to understand the direction of the flow of your case. So the lawyer will try to bluff you. He will say, oh, we are going to win this. Yeah, we are going to win this. Yeah, judge is on our side. Didn't you see how he looked at the other guy? You say, I don't know, I can't read the judge's expression. Oh, he was very angry, he was very annoyed with the other guy. And you may believe him. Or he may say things like, he was very annoyed with us. Now you are scared. So what should I do? Don't worry, I'll figure out something. Now you are scared, now you feel that your entire fate is in the hands of your lawyer. See, lawyers can't predict the future. That much is very clear. They can't predict judiciary, they can't predict a judge's behavior. They pretend to be able to predict the judge's behavior. So, they don't know what is going to happen, whether the case is getting over in 1 month, 2 months, 6 months, 1 year, 2 years. They don't know anything. But they pretend. And they misguide you. These are contractors who misguide you. And you can't hold them accountable. You can't go back to them and say, hey man, what is this? What were you saying and what happened? How come? If he's inexperienced, he may just say, well, I don't have enough experience. If he's experienced, he'll say, yeah, but the judge was moody and I don't know. Sometimes judges are moody. The judge was very bad. Courts are like that. Judiciary is like that, which is also true. Judiciary is also a place of surprises. It doesn't help you that judiciary is a place of surprises, where judges, especially High Court and Supreme Court judges, are practically gods. They can do anything, they can say anything, they can get away with anything. Huge egos, massive egos. It doesn't help that the judge's ego seems to be more than the logic. When your lawyer talks, when the opposite side lawyer talks, it seems more like ego massage. Milord, milord, milady, milady. It's more ego massage and less logic. Your lordship, I most humbly submit. Obliged, my lord, obliged, my lord. All those mannerisms, all that's happening. It seems more like an ego massage. It is not clean logic. It's not clean. There are emotions. There are too many emotions. The judge got annoyed. The judge got irritated. Hey man, you are a judge. It's your fucking job to listen with a cool mind. Not show anger, not show irritation, not show attitude. You're a fucking judge. Be a judge. Even in lower courts, even in magistrates' court, judges show attitude. They act angry, they act irritated, they act annoyed, they are entitled. If you say something, they take offense. They are sticklers for procedure. You don't know, they are unpredictable. They may pass an order, they may not pass an order. They may say kept for orders and not pass it for months and months. They may pass orders, you don't know which direction they are going. They talk as if they are scolding the opposite party. They go on and on in their scolding their opposite party, your opposite party in the judgment. But then in the operative part of the order, that's the only part of the order that really matters. They kind of give an escape route to your opponent. Throughout you're going to feel, the judge is going well, the judge is going well, it is going on my side, it's going on my side, and then suddenly you find that the opponent has escaped. What the hell happened, my lord? What the fuck, my lord? You feel like saying that. What the fuck is happening, man? What is all that about? What is all that bhashan about? Why did you give all that bhashan and all that gyan? And then you just, in the operative part of the order, you just let him off the hook. You let him go free. Or you let him go with minimum consequence. What is going on, man? You feel like saying that, but you can't say it. He's a judge. He'll say, yeah, go and appeal now. You want to appeal, you appeal, or file a review petition. You are helpless. So, yes, it is a whimsical place. It's a crazy place. Lawyers take advantage of this. The craziness, the whimsicality, the utter lawlessness of judges. The utter lawlessness, the nonsensical behavior, the moodiness of judges. One judge can do one thing, another judge may do another thing. A third judge may do one thing in the morning when he is alert and a different thing in the afternoon when he is sleepy. You can't hold them to any kind of a standard. So you can't hold judges to a standard, and because of that you can't hold your lawyers to a standard. Because it's unpredictable. Outcomes are unpredictable. Judge gets irritated, he passes an adverse order. He's not supposed to do that. He's not supposed to do that. He is supposed to be strictly on the law, strictly on justice, strictly on delivering the right judgment or the right order. He is not supposed to be delivering an order adverse to you because he got irritated or moody, or because he got convinced by the other guy for no good reason. You see judges who just get convinced automatically. They just get convinced. They get stuck on a point. And then the other guy, maybe your lawyer, if you're unfortunate, your lawyer will, if he is a good lawyer, will struggle to dislodge the judge from his opinion. The judge is not supposed to have that opinion. The judge is supposed to be equidistant. The judge is supposed to listen with an open mind. But the judge just seems to go off at a tangent and he forms an opinion. And after that, nothing can dislodge him from that opinion. Especially higher courts, especially High Court and Supreme Court judges. Very moody, very whimsical. They will scold you. They'll scold your lawyer. They'll threaten him. They'll say, we'll impose cost on your party if you keep arguing. We are going to impose cost. Be careful. For what, my lord? I'm doing my damn job. I'm doing my job. My job is to convince you. That's what I'm doing. And what you are doing is not unprocedural. Very often judges go against procedure. Very often judges go against, they go beyond their jurisdiction and pass orders which they cannot pass. So they just basically do whatever they like. They do whatever the fuck they like. And you can't say it to their face because they'll explode, they'll get angry. And in their courtrooms, they are kings. So your lawyers get advantage of this kind of whimsical behavior. And because these guys are whimsical, you're not able to enforce a contractual behavior from your lawyer. But what you can do is, you can gain some kind of traction on your lawyer. Some kind of traction. Okay, traction is what a tire has on the road. The grip of the tire on the road is called traction. You need traction on your lawyer. You need traction on the whole situation. You need to be able to control the fate of and the direction of your own case. So, what are the things you can do? You can draw up some kind of a contractual document, or you can at least exchange emails with your lawyer saying, look, in the course of your meeting, this is what you said, this is how we expect it to go, and you are going to charge this much. Now, I want to know what happens if it doesn't go the way we expect it to go. What are your charges going forward? You need to tie him up to some kind of standard. You need to tie him to that standard. You need to tie him to milestones. You need to have some kind of reference points. So, write an email to your lawyer. If he doesn't write you an official email putting down his proposal in writing, you write an email to him putting it all down in writing. And then all your payments, make it in check. They may ask for cash. Very often lawyers ask for cash. Be careful, don't give cash. Give check. Have communication around that check every time. Make it a clear thing that I have paid you this much, I have paid you that much. And there are kickbacks. Kickbacks are commissions. They will take big commissions by engaging a senior counsel. So what they will say is something like, hey, listen, you know what? I really need to have someone better to argue. The judge is not listening to me, so you need to engage someone better to argue. So I'll get you a senior counsel. He'll say it's a cheap senior. He's cheap. He's inexpensive, relatively inexpensive. He's not charging 15 lakhs. He's only charging 5 lakhs per hearing. Now even 5 lakhs per hearing will kill you. But he'll say, it is getting over in 3 hearings. So 15 lakhs, but your matter is worth 1.5 crores. So it will get over. What happens if it doesn't get over in 3 hearings? You paid 15 lakhs to the senior counsel. He's probably given 5 lakhs as kickback, as commission to your lawyer. Whereas what you have paid him in the beginning is only 2 or 3 lakhs for the entire case. He has already taken 5 lakhs as commission. And 3 hearings later, the case is still going on and you are in a panic. You're like, what's going on, man? What's happening? Because if I keep paying 5 lakhs, I'm going to go bankrupt. It's not going to be worth it for me. Lawyers kind of put you on this very slippery slope. So your effort should be to gain control over the whole situation by saying, are you going to argue the case yourself or not? I don't want to engage a senior. Say it right in the beginning. Are you capable of arguing? Yes or no? And then go to the court, be there, be present, watch your lawyer arguing. It is important for you to be present. He may say there's no need for you to come, but go there. Be there. Sometimes it's tough because you may be living in a different city. If you've done your paperwork, if you've done your emails, gained some amount of traction and control over the lawyer, and if he slipped up, doesn't appear, etc., you have written emails to him promptly saying why there was a hearing on this date, you didn't appear, there was a hearing on that date, you didn't appear, on this date you appeared late, the matter was kept back and then it did not reach, or it was kept back and it reached but you sent a junior to argue, you did not appear. If you keep track of these things, the performance milestones, the things that he has done, you can spark a dispute with your lawyer. Now, what is a dispute? A dispute is basically, you said this, you promised this, you did not deliver. I have a problem with that. Explain. Explain what happened. You owe me an explanation, proper explanation in writing. Come on, explain. So you're going to hold him accountable. Now, what happens if he is not accountable? If he's taken your money and he is not performing at all, and he's just let your case go. Well, here's what you can do. These are my suggestions. Now, people are afraid that their lawyer is going to screw their happiness. Yes, that's a fear. Yes, that is indeed a fear. But what I'm suggesting is this. Either you have to have control or you're going to let go of all control and you're going to be a hostage of your lawyer. My suggestion is, here is a way to fight back, and I can support you on this. Here is a way to fight back. As I said, to begin with, you have to have written communications with him, email, official communications. If your communication has been on WhatsApp, write an email sending him all the screenshots of the things he has said to you on WhatsApp. If he has sent you voice messages, write an email adding those voice messages to your email as attachments. Send him attachments saying this is our communication, this was what you are supposed to do, and this is what has materialized. What do you have to say about this? What are we doing? How are we going to fix this? How are you going to fix this? Now let us say he is completely uncontrollable. He will not let you control him at all. He goes out of control. He goes rogue. What are you going to do next? If you fail to gain control like that, then the second thing is you write a detailed complaint to his bar council and bar association. Write to the bar council of the court where he practices, where your case is, about his malpractice, about his wrong practices, about his lies. Write a detailed complaint chronologically. On this date he said this, this is our, see the attached email correspondence. Then he said this, this is our WhatsApp exchanges. After that, now he is doing this. At least create a situation where he will have to explain to his bar council or bar association. Create that situation. Will bar council hold him accountable? Not very likely, especially if he is powerful, popular in his fraternity, etc. Maybe nothing happens. No problem. No problem. You may also complain to the judge himself, like write to the registrar, write an email to the judge, to the through the registrar, or through whatever mechanisms there are. Write an email to the judge. Complain about your lawyer with reference to your case number. Complain about your lawyer. Say that he has continuously not been appearing. Put it on record. Create records. After you have done all that, make a video. Make a video. Talk about it in a selfie video. Talk about this lawyer in great detail. Have a definite ask, like your ask should be refund my amount. Could be a part of it. It could be a partial refund. Listen, you said you are going to represent me for the whole of the case. However, you have only done this. You have not done that. I demand that you refund 50%. You have done the drafting, you have done the filing, you made 1 or 2 appearances, you have not, represented me through the rest of the case. I expect I will have to pay another lawyer a fairly large amount when I engage him. I demand that you give me an NOC, no objection certificate, for engaging another lawyer, and I demand that you give me a refund of 50% and an apology. Make an audio, send it along with the email, demand it. And after that, make a selfie video. Make a selfie video which I will publish on my channel. Start very, very gently saying, this is the name of the lawyer. I had engaged him for my case number so and so in such and such court, for defending me in front of the magistrate. And this guy has hijacked my case and I am suffering consequences. He was supposed to get anticipatory bail. He never appeared at the anticipatory bail hearings. As a consequence, I actually was arrested. I went to jail. I was in judicial custody for 1 week. Then after that, my wife got another lawyer and they got me out. Now I'm out on bail. This guy didn't get me anticipatory bail. Now I'm out on bail. And now this guy is acting funny with me. And if he has taken a bribe, often they will take a bribe saying, oh, we need to bribe the magistrate, we need to bribe the judges and so on. If he's taken a bribe, talk about it. You may think this is a risky strategy. It may be. I think it is a rather safe strategy. Because if you talk about these things, it puts them on the defensive, because these are all things they like to do, but not openly. They like to do these things, but they like to do it hush-hush, not openly. It hurts them if you do it open, if you talk about it. It may be factual. He may say, I'll sue you for defamation. When you have a whole narrative, you have an entire conversation and email conversation going on. If you make this video, which is 80-90% standing on factual metrics, email correspondences, WhatsApp messages, voice, etc. And on 10% you don't have proof. You may not have proof that he has taken bribe for the magistrate. He asked for 2 lakh rupees in cash and you gave him 2 lakh rupees in cash, supposedly to give bribes, out of pocket expenses, things like that. Get whatever proof you can. If you made a bank withdrawal, great proof. On this day I made a bank withdrawal. This is my check number. I withdrew 2 lakhs. I gave it to this guy. You can argue it, and he is not going to get a successful defamation case against you, and it's very unlikely that he will even try for defamation if I am involved. So if I am publishing the video, the intent behind this, there are 2 intentions. I am going to be very clear. One intention is to enable you to get a grip, get traction on these guys. So to create traction, you need to go public. So for that, you need a video. We are going to send the video to him for his rebuttal. If he has something sensible to say, he can say it. If he threatens to go to court for defamation, etc., I will publish it along with that threat. And then he can try to file a defamation case against me, because I am publishing it. I am publishing that video. You are speaking, I am publishing, and I am publishing because you have a right to speak publicly about such matters where you have been put to a loss, where someone has exploited you, where someone has arguably exploited you and is defiant, is not willing to give an explanation, is not willing to make amends, is not willing to compensate you, is not willing to refund you. I am willing to stand with you and fight. And then if it goes to court, let it go to court. If it goes to court, I rely on this. I will make a video at every possible turn of events. He is going to get really famous the wrong way. He is not going to like getting famous through my channel. It may be a small lawyer, it may be a big lawyer. My whole thing is, it is not defamation if you actually have a factual matrix. He is a professional, he is supposed to behave professionally, and if he has behaved unprofessionally, it is your right to speak about it and rein him in and control him and make him apologize and make him compensate you or make him refund you. It is your right, and I will stand with you for that right. The second thing is, there's a principle I'm standing for. It is a wider principle. It's not just you, it's not just your case. Public needs to be educated about all the possible things that go wrong, all the things that can go possibly wrong when they engage a lawyer. Public needs to be educated. Public needs to know. They should not consider lawyers to be gods. They should not consider judges to be gods. They should not consider themselves to be helpless. They have to have a realistic sense of what is going to happen in any case. They need to be informed, they need to be educated, and your videos will help in educating the public. If you share your story, it educates the public. Now, what happens if this lawyer, before the story is published, refunds you, makes amends? Excellent. Your story will not be published because he has made amends. He has given you a resolution that is satisfactory to you. He has, for his wrong actions, he has apologized, or in any case, he has made amends. That video will not be published. He will be able to save face to that extent. If one video has been published, then it has been published, then it's too late for that video. Maybe the next video won't be published. He will be allowed to save face to that extent. Are we out to defame him? No. We are out to educate the public. It is not defamation if it is factual. It is not defamation if it is in public interest. Educating the public about the behavior of lawyers, it is not wrong, it is not defamatory. If a professional is inefficient, or a professional is a crook, a lawyer is a professional. If he is inefficient, or if he is a crook, or if he has malpractices, or if he doesn't know his work, if he is ignorant, if he is misguiding you, any of these things, the public deserves to know so that they can make an informed decision about engaging that lawyer or such lawyers. And they need to learn how to engage with a lawyer within a safe parameter. You can't go and sue a lawyer in consumer court. It's not there. It's not that relief, that remedy is not available to you. Although they are service providers, they are contractors. But that remedy is not available to you. So we have to create remedies. There are, really speaking, very few easy remedies. Going to bar council may not yield results. Therefore, making a video may yield results. Now, can there be a backlash? Of course there can be a backlash. There can be a backlash against you, there can be a backlash against me. A lawyer or any lawyer may refuse to represent you or me. Can it happen? Sure, it can happen. Will it happen? I realistically don't think it will happen. Because I realistically think that when you target the crooks among lawyers, you help the honest ones among lawyers. There are honest guys who are not able to make a living because the crooks are taking away their livelihood unscrupulously, by wrong means, by misguiding, by misleading, by lying. When you target the bad guys, you strengthen the good guys. The good guys may give you service. The good lawyers may support you. The good lawyers may stand with you. They may say, yes, we had been thinking of this, we were looking at this problem and we did not have a solution. What could we do? Until people learn to stand up for themselves, what would we do? Correct, exactly. So, you need to take that chance. You need to go out on a limb in order to get justice. Is that fair? No, it's not fair. I wish there was a world where you could get justice without having to fight for it. But in this world, justice comes to those who fight for it. And that is the only way you can get justice. You have to fight for it. You have to earn it. You have to, you have to pay for your justice with sweat and blood. You have to be prepared to pay for your justice. Pay not only monetarily, pay a price for your justice. And if you are willing to pay a price for your justice, it's war. It's basically war. If you are willing to go to war, if you are willing to wage war against injustice, there is a very high likelihood of you winning. Winning the kind of victory that you'll be happy with, the kind of victory that will make you proud, the kind of victory that will make you have a story, it will give you a story to tell your grandchildren and your friends and your family members. It will give you a story. It will give you a sense of self-worth. I fought and I won. Now, even if you lose, I think it will be a partial loss. It can be a substantial victory. So, I will highly recommend, I will highly encourage you to fight this battle in a methodical way. The method is, just to reiterate, number one, have a lot of record keeping and record creation. Write emails to your lawyer about the terms of engagement and the milestones and the payment timings of payment and when you are supposed to pay him and what is supposed to be achieved by each payment and everything. Write it all down. Send emails. Don't let it be casual. If it is a voice call, if he's not allowing you to record it, reduce it to writing immediately after your conversation and send him an email. And say, bro, this is what you have said. This is what I'm going to hold you to. It has to be very clear to him that you put it in writing and tomorrow you're going to refer to that. That email is not just a formality. You're going to refer to it. And if he wants to change the fees, if he wants to change the way he charges or do make any changes, he needs to consult you first. He needs to tell you. And you need to put in place a system where he is answerable to you. If there is an order, he has to send it to you on email. Today, we received this order. Rojnama, this is the screenshot of the Rojnama. This is the cause list. This is the, whatever it is. These are the interim orders. Let him be sending you emails so that a record is kept of his performance. That needs to be done. If a junior appears instead of your lawyer, it has to be written down. There has to be a record of that. Today, you did not appear. Today, this advocate Shilpa appeared and took another date. If there is scope for dispute, if you can just talk it out, argue it out with him and he is listening and he is reasonable, then don't unnecessarily blow it up. But if he is unreasonable, if he has given you cause for grievance, if he has created cause for dispute, if he has gone rogue, if he is doing things without consulting you, if he is not appearing when he is supposed to appear, if he is making filings, if he is filing documents without consulting you, for example, which sometimes lawyers will do, if he is misguiding you and you later on realize that he has misguided you or kept you in the dark, have communication with him, write it all down, write emails to him. And the final step is, if after getting an email, if he is not reasonable, then make a video which I will send to him for rebuttal. I will send that video. Your client, Mr. So-and-so, says this. And this is going to be published after 6 days. If you have something to say in this matter, please revert to me by 6 p.m. on such and such a date. Otherwise, next day it gets published. And if you send me a rebuttal, I will put that rebuttal as part of the video. You can send me a video or a rebuttal in writing or as an audio or as a selfie video where you are speaking your side of the story. So I'm listening to your side of the story. I'm giving you 6 days. And if you don't do this, if you threaten me, if you threaten to go to court with a defamation case, if you issue a cease and desist, I will publish the video with that cease and desist. I'm Krish the Urban Naxal. Jai Maharashtra, Jai Hind, Jai Jawan, Jai Kisan.